So good morning. I'm not going to reintroduce myself. I think everyone knows who John Paff is, and his bio is in the pretty yellow booklet. I think I'll start with this question. John, how does someone enforce their rights under the Open Public Records Act? What are the options available to them to do that?
Well, I mean, the obvious answer is that there's two ways of doing it. One is through the Superior Court, through an action in Superior Court, which must be filed within 45 days after the denial of the request. And the second way is through the Government Records Council. The first important thing, though, when you're thinking about enforcing a records request, a lot of times denial of access, the problem is that people, a lot of times when I see people's requests, they're unclear. They're vague, they're ambiguous, and they're hard to understand. They're overbroad. So I urge people to take a significant amount of time, a reasonable amount of time, and craft their request carefully. And I think that also benefits, when you're at the lawsuit stage, it's important, in my view, to have a clear request, to have their denial or whatever they send back, and perhaps a letter back to them explaining why their answer is not acceptable, even citing the law to them and saying, this is not right what you've done. Would you please do it again? And I think if there's a polite, civil discourse in writing between the custodian and the requester, I think that bodes well. That helps out. I think that it's not lost on the courts and the Government Records Council that the government requester really tried to get the records. There's something I don't like about people who are really looking for lawsuits rather than they're looking for records. You really should work with a records custodian to try to get the records and ask them to help you if you need it. But that's the way that but the actual mechanism for enforcing it. I find that I don't really have to enforce that many records requests because I usually get the records that I want. But when I do have to enforce one, I find that my position is justifiable, and I've tried to exhaust every remedy I can before actually having to file the lawsuit. You have to remember, the filing the lawsuit is going to cost taxpayers money. It's also going to invite criticism from the people if you sue your town. And people are going to criticize you for wasting taxpayers' money, even though that's not fair. It's not a fair criticism in my book. I mean, if you're suing, but I like to be able to have a defensible position by showing how hard I tried, everything I went through, my whole correspondence chain. I want to be shown that the clerk or the denial was unreasonable, or that there is an issue that needs to be decided on a statewide basis that needs the court's intervention, not just making a request, and 10 days later they didn't answer, so the first thing you do is you file a lawsuit. That's not really the way to go about OPRA. So I urge people that when they are using their OPRA request, it's a powerful tool. And yes, you can run a clerk, you can drive a clerk crazy with these things. I mean, you can put in request after request, and I know people that do that. I don't have a lot of respect for that position, just to make requests for the sake of making a request, or using it as a tool to harass or somehow upset the clerk and the administration. Ask for records that you need, and use the tool wisely and fairly. And I think that you're going to end up with a better reputation as far as your use of OPRA. I think there's a lot of people that have bad reputations, and perhaps deservedly so, by not using the tool fairly and using it to actually harass government officials.
Now, John, sometimes when people make OPRA requests, the clerk may say that the documents or information they were requesting are protected or confidential because of privacy concerns. Could you talk a little bit about what's the standard in New Jersey regarding whether or not information is private, and if you meet that objection, how do you deal with it?
Well, it depends on what they say. I mean, first off, if they just simply say it's private, that's the equivalent of them saying you can't have it. I mean, that's not a good description. They have to say something like, you can't have it because it's advisory, consultative, and deliberative, or you can't have it because it would violate a particular individual's right to privacy. There's the kinds of answers I get. It's fairly nuanced, because sometimes the first thing I get from some clerks is this. I ask for I ask for something, and they say, to the extent that it exists, it's confidential for a variety of reasons, and you can't have it.
Is that a sufficient response?
No, I don't think it is. And what I say back to those clerks, I say, well, would you first identify whether or not there are any records within the scope of my request that exist? And for each of those records that you've identified, describe them with as much detail as you can that would not undermine the privacy interest or the confidentiality interest that you're asserting. So,
why is that important?
well, it's important because, first off, I want to know if there's an existing record. I'm asking, like, I just put one into Lavalette. It's an interesting one because they talked in one of their executive sessions and one of their public meetings about disciplining a police sergeant. But they won't say why. So they disciplined the police sergeant, they're disciplining him, they're appointing a hearing officer, and at the same time they're granting him medical leave during the pendency of the disciplinary action. So I said, if there is a police report or incident report that relates to whatever it is that you're disciplining him for, provide me with a copy of that report. They're likely to come back and say something like, well, if there is a police report, you can't have it. But I feel that they have a responsibility, and I can prove they have a responsibility, to at least identify the record so I know if I'm on the right track. If a person were to file an action with the Government Records Council, the Government Records Council, this is free. You can file it for no cost. You can file a denial of access complaint with the Government Records Council. If the GRC, when they get the complaint, the first thing they're going to do is send a statement of information and require the custodian to fill that out. And that statement of information requires that custodian to say, identify every record that is within the scope of the request, regardless of whether you feel it's exempt from access or subject to access. So I call the custodian, or I write to the custodian, I say, look, if you're not going to tell me whether or not any records actually exist, I could go to the Government Records Council, and they're going to, in 5 days or 10 days, going to make you explain what records exist. So instead of me wasting everybody's time and filing the complaint with the Government Records Council in order to determine what records exist, and it's just an ultimate, it will happen, why don't you just tell me now whether or not what the records are that exist and identify them so that I can judge for myself whether or not I might agree with you. Your basis for confidentiality might be, your stated basis might be persuasive. But you can't just tell me it may or may not exist, and if it does exist, you can't have it. So I almost have a standard letter that I send back to these custodians advising them of what my rights are, and usually I'll get a better response the second time around.
And that's important for a couple of reasons, because if a record doesn't exist, you don't have a right to it. The Government Records Council and Superior Court have said that, look, if there's no record to give you, then you don't have a claim under the Open Public Records Act. So, and there are, in my view, exceptions to that, but in general, if the record that you're asking for doesn't exist, you're not entitled to it. So, to put it bluntly, you're sort of wasting everyone's time if in the beginning you file a lawsuit. And I've done this. I've been in the position where I filed lawsuits, or I filed Government Records Council cases, and it ends up the documents we're looking for don't exist. And then someone puts in a certification saying that they don't exist, and that's a case, I'm probably going to lose. So I'm not interested in spending anyone's time on cases that I'm going to lose. So if you can find out whether or not, if you get sort of like a wishy-washy response regarding whether a document exists, you make them articulate whether the document exists. Well, why is that important? Because really both sides need a good faith basis for taking the position that they're taking. So yes, Mike.
I had an instance many years ago where I was requesting information from a government agency. Thank you. I was requesting information from a government agency. I wanted to see the audits of their records. And I was told at the time that they didn't have their audits, although they were required to have them by law. So in that instance, the record doesn't exist, but it's supposed to exist. What do you do?
Well, that's an interesting question, because you sort of hit on the exception that I talked about. There are two situations where I think that if you request a record that doesn't exist, there is a remedy, in my experience. The first issue is, let's say there's a series of meeting minutes that are either in draft form or haven't been approved. I've been successful in getting the court to order the public agency to approve the minutes and then under OPRA provide them to the records requester, all as part of the same litigation. So I sort of call it a hybrid case. I'll say, look, under the Open Public Meetings Act, you should have approved these minutes, so do that. Under the Open Public Records Act, give copies of the minutes to whoever requested them. That's the first situation. The second situation is in Bergen County, I forget exactly who the name of the plaintiff is, so I won't say it and get it, chance getting it wrong. But the plaintiff requested copies of, I think, a use of force report involving an incident. And the defense was that the use of force report did not exist, therefore there was nothing to be given, therefore, judgment for defendant, dismissing plaintiff's case. But what Judge Doyne did, he said, look, you are required by law to create that record. I can't force you to create that record, but you really should create it because there's this other law that requires you to create it, and as soon as you make it, you give it to the plaintiff. And why is that important? Well, in that case, as my recollection is that Judge Doyne, his reasoning was that, okay, you have to give a record once it's created, therefore plaintiff is a prevailing party. And why is that important? Well, that's sort of the hammer under OPRA, because now the plaintiff can potentially get attorney's fees. And that sort of really stings when the defendant the public agency has to pay both their own lawyers and the plaintiff's attorney.
It doesn't really sting them as much as it's taxpayer money is what it is. And a lot of these guys, I've been involved in some cases where I think that they almost deny the request on purpose to have me file a lawsuit in order to keep the billable hours going. Some attorneys do that, and I don't think that's right. The most important thing is that the fee shifting provision under OPRA is very important, because if you don't get your fees, well, a lot of attorneys take these cases on like a contingency, not really a contingency. Yeah, a contingency, where if they win, they submit their bill for attorney's fees to the public agency. If they don't win, they don't submit their bill to the public. So what happens is the attorney ends up working for free, and that's going to wear that attorney out pretty quickly because he has a living, he's got bills to pay. So it's really important that, that for the attorney and the party to win the lawsuit so they get the attorney's fees paid. And we'll get to the Open Public Meetings Act a little bit, but there's no attorney fee shifting provision there, so it doesn't matter how right you are, the government is not going to pay your attorney's fees. But that's why it's one case I'd like to see, and part of what I try to do is come up with cases that will change things and clarify things, is that if a public agency will not tell you whether or not a record exists, despite your numerous requests to please give me some information so I know that I'm not wasting my time filing a lawsuit for a non-existent record, they still are ornery enough to not disclose that bit of information that you need. And you end up filing the records, you file the lawsuit, and it turns out that truly the record does not exist. And then they say, well, since you didn't get any kind of a record in response to your lawsuit, you're not the prevailing party, so you don't get your attorney's fees. I would like to get a case where the facts are good and the custodian is obstructing the requester, and the court says, you didn't give this plaintiff enough information within which he could reasonably determine whether or not he should file the lawsuit. So that really the fact that your failure to do that should still trigger the attorney fee shifting provision, because you didn't play fair. You didn't turn sharp corners with this custodian. You basically baited him into having to decide to file a lawsuit and put his money down in order to harass him essentially by not giving the information he needed so we could act appropriately and responsibly. And that's wrong, and you're going to pay attorney's fees for that. I'd love to see a case like that come up, because I do find the hide the ball games going on with the government entities, some of them, where they just simply will not advise you as to whether the record exists or not.
Yeah, John, and it's a little frustrating because sometimes, and I know this is being recorded, but sometimes we will use the GRC to do that, because the appellate division requires the GRC to get a certified statement from the records custodian listing the documents that are responsive to the OPRA request, regardless of whether or not they must be produced. It's just whether or not they're responsive. The issue of whether they're privileged or confidential is separate. Now, if you go to the trial court, go to Superior Court, you're not necessarily going to get that list. When I file my lawsuit, maybe there'll be a certification saying this is what's responsive. Maybe there won't be. I don't control that. So then I have to go to court. I have to ask for a listing. Maybe the judge will give it to me. Maybe the judge won't. So sometimes we'll go to the GRC simply because we know if we go to the GRC, we'll get that. They're required to give that certified statement. And I saw 3 hands. I'll go to the first one that I saw.
Oh, yeah. Oh, I see.
All right. What happens if the custodian articulates that no record exists, and you find out in the minutes that the record actually does exist? You get a copy of the minutes, and you go back to the custodian again and says, well, according to these minutes, this record does exist. They maintain a position that the record doesn't exist. Eventually, you file, a complaint. What do you do under those conditions? As you know, I'm already involved in that, but I just want to get some feedback from you to see how you perceive that.
Well, what I tell folks is that, look, if somebody is willing to certify that a record doesn't exist, that's a bit of a get out of jail free card. So you need to have some evidence showing that the record does exist, like real evidence. And if there was a reference made to it in some other official document of the township, that would be pretty good evidence.
And I think what you would do with that is, I think that's why OPRA has the knowing and willful $1,000 penalty, is that type of a thing, to require, and they're not often, it's not often enforced, but the Open Public Records Act does have a provision to define a civil penalty of between $1,000 and $5,000, I think it is the penalty that can be levied against any, not just the clerk, but any government official that unreasonably, knowingly and willfully denies access to a record that is unreasonable under all the circumstances prevented. And that's a hard burden to reach, but I think that a person telling you that a record doesn't exist and denying an OPRA request on the basis of the record not existing, when the record did in fact exist, and they knew that it exists or should have known it exists, would be the type of case that you would want to take to the Government Records Council and have them find this person guilty and fine them and make sure it gets in the newspaper as a way of showing all the other custodians don't play fast and loose with that. Because as Walter said, if they certify that a record doesn't exist, I've been stopped dead in my tracks lots of times in court and in the GRC. They say it doesn't exist. I cannot prove that they're wrong. So that's pretty much it. That's the end of the game. So if you do happen to catch a clerk playing that, be sure to take them. And that's an important, another thing is about, first off, there is an appellate division decision that says that the Superior Court does not have jurisdiction to enforce the $1,000 penalties. I don't understand why the appellate division made that decision. I don't think that the appellate division is right. I think that that's not the way I read OPRA, but that's what they've said. So if you are going to enforce a penalty like that, you pretty much you should go to the GRC in order to have that done. Yes. And I think that's been done maybe 2 or 3 times.
Yes, I'm only aware of 2 instances where the GRC has levied a penalty that wasn't reversed on appeal. And yes, both, if you think you want to go for a penalty, and unless you're willing to appeal it to the Supreme Court, you should file with the GRC. And also, either the GRC or the Superior Court has held, I don't remember which, has held that lawyers cannot be fined under OPRA because they're regulated by the Supreme Court. So only the Supreme Court can penalize penalize a lawyer for conduct relating to an OPRA request.
That was I just want to say something about that. That was, I believe, a ridiculous decision. What that was
Tell us what you really think.
The Attorney General of the state of New Jersey issued an opinion letter stating that because lawyers are highly regulated already in their profession, that they cannot be also regulated under the Government Records Council. One of the leading cases in defining whether lawyers can be held accountable for, I believe that one of the parties in the case was Knight, Knight, and the Attorney General's opinion on the matter did not even reference that leading case when coming to that conclusion. So I don't really think, and there is an unpublished appellate division decision. It was Flavio Comones versus Township of Edison, where the court opines that an attorney can be found liable under the knowing and willful violation. So that's at odds with what the Attorney General has said. So it's certainly not settled case law. And what it would take is a good set of facts where the attorney was actually responsible, a GRC complaint that says that, well, we're going to dismiss your knowing and willful violation count but just only because he is an attorney and the Attorney General has told us that this attorney cannot be held liable, then to appeal that legal decision to the appellate division and see if we can get some sort of sense made out of it. That's what it would take. But yeah, according to the GRC now, I predict that no matter what the attorney did, they're going to hold that the attorney is not, by virtue of the fact of being an attorney, is not subject to the knowing and willful penalties.
Now, I think, Mr. Gettler, do you still have a question? Yes. Okay.
Your statement about the GRC requiring a list of documents within so many days, the case I have against our municipal clerk, which now goes to administrative law, we're now over 3 years later, he has yet to submit a list of the documents to the GRC.
Well, the GRC is well, I guess what I should say is this is what they're supposed to do. And in many cases they do. I mean, I just had one the other day of a case that we filed in May where the letter comes out in September saying, okay, we've received a complaint. You know, the 4 months afterwards, they acknowledge the complaint and actually require. So there's some sort of staffing issues down at the GRC, and this does happen. But I understand that the GRC sometimes takes 18 months, 2 years, 3 years to adjudicate a case, but I frankly, I can't say I've ever seen a situation, you're telling me something is new to me, where they've actually taken this long to require them to properly complete the statement of information. Okay, so they ordered them to comply, and they didn't comply. And I guess what we think then is they should refer this matter to the Office of Administrative Law or whatever they need to do in order to compel. I mean, the whole system sort of comes apart at the seams if the custodian doesn't have to participate and nobody can force the custodian to participate. I mean, it has to be compulsory, and there has to be some sort of process that would require the custodian to obey the orders of the Government Records Council. In your case, I'm not sure, I don't know about your particular case. I have no idea why that would have happened, though.
Okay, was there a question in the back? Yes.
Can you hear me?
I can hear you fine.
I just wonder if you could speak to the definition or interpretation of responsive. The custodian of the document gets to decide what's responsive and give you the list of the responsive documents, but aren't they putting their judgment of what's responsive? And I could foresee them claiming later that, well, yeah, you can have that too, but it wasn't really, and therefore they were not deliberately evasive.
That's the reason why you have to make precise OPRA requests. If I ask for all the minutes, I would ask for the minutes of every public meeting that occurred between January 1st, 2012 and March 31st, 2012. There isn't a whole lot of wiggle room on what that means. If there was a meeting that was held between those two dates, the minutes for those meetings are responsive to the request. If you start asking for, if your requests become vague, more vague, and you ask for things that are all the minutes between January 1st and March 31st at which a particular issue was dealt with, well, then they might, there is a certain exercise of judgment. So when you get to something like that, just ask for all the minutes for that period of time, then you make the determination yourself. The more judgment you give to the custodian to determine which records are responsive to your request, the more you're inviting that custodian to exercise his or her discretion in a way that might not be in your favor. So it's dangerous when you ask people to a qualification of what the records contain. Give me everything in this category of records where X is true. When you start asking for things like that, that's where they're going to be able to exercise their discretion. And you just have to accept that when you get their response. You might have to follow up with additional OPRA requests to make sure that your response is complete. That's why I generally don't ask the clerk to interpret anything. It's usually factual. things that are not reasonably susceptible to any kind of disagreement, like the minutes of the most recent 3 executive sessions for which minutes are available. I don't have to know the dates of them, but they're either are or are not available at the date that they get the request. And they can then say, these are the most recent 3 minutes. And that's factual, that's close enough to being factual. There's a certain exercise of discretion, but it's not based upon them evaluating anything other than an on-off switch, whether it's available or not available. So I don't think you have to, I think generally if you make the request, and you make them detailed enough and specific enough, you're not going to have a problem with them, with any serious disagreement on what records are responsive.
Right, and the issue is, are you asking the clerk to do research or to do a search for records? And the case that gets thrown a lot at records requesters is MAG Entertainment or MAG Entertainment, and I forget.
And Bent versus Stafford.
Yeah.
Those are the two, the go-to cases for the custodians.
Those cases are sort of abused a little bit because the request in MAG was really a research project. And so if your OPRA request is a research project, that should be rightfully declined. I think the request in MAG was something like, it was to the Bureau of Alcohol and Tobacco, please look at your records and give us the files anytime that the Bureau issued these types of licenses or did this type of analysis. And that's a completely inappropriate OPRA request. But most OPRA requests are not like that. I think there's sort of like a subtle distinction that gets lost. I think sometimes folks make broad OPRA requests that require a lot of work, and then you get MAG thrown at you. No. An OPRA request that requires a lot of work is still a valid OPRA request. It may be that it involves a special service charge, but it's not overbroad if you simply ask for a high volume of documents. So again, getting back to sort of the original question, you want to minimize that discretion. Really, in my ideal OPRA request, the clerk shouldn't be exercising any discretion. When the clerk, what I try to tell folks is, when the clerk has to make judgment calls about what documents they have to give you, that's probably an inappropriate OPRA request. Clerk is not a librarian, the clerk is not a research assistant. Okay, so you try to be as specific. Well then, what folks tell me is, well, Walter, I don't know exactly what I'm looking for, or I'm not sure exactly what these records are called. Well, there's nothing that prohibits you from picking up the phone and talking to the clerk, and I bet that most clerks, or maybe even visiting the clerk, and I bet you that most clerks would be open to that, and you say, well, look, Madam Clerk, I'm looking for information that says X, Y, and Z. What documents would have that information? And the clerk, who takes pride in their job, will say, oh, well, that information is in these types of records. Well, boom, that's what you should OPRA. What the clerk identifies, you should OPRA. Now, the clerk is not obligated to answer your questions, but if you appeal to the side of a person that thinks that they're doing a good job, and you come in with a question, I think they'll answer you and they'll work with you. So that's what I tell folks.
As far as that goes, just one is the Hoboken case, the Mason versus Hoboken, puts an affirmative duty on the clerk to work with a records requester.
Supreme Court.
The Supreme Court
case.
I see, yeah, Supreme Court to work with a records requester. I mean, the ultimate goal of the Open Public Records Act is not to play games where the clerk plays the hiding games and you play the finding games. It's not a hide and seek game. The purpose of it is really to get information contained in records into the hands of the public so that they can use the information for whatever purposes they choose, and that's the overarching goal. So I have it on my blog. I have a little blurb that I send the clerks, and it says, I don't know what types of records you have. I don't know how you arrange your records in this particular way. I don't know what you do. I need help in determining. I don't want to craft an OPRA request that's overbroad or burdensome on you or your office. I want to be able to get the records that I want with minimal disruption. Could you help me? Tell me what classes of records are available. I put this in writing to them as part of my OPRA request so that I can better evaluate it. So I ask for what records I think I want, and then I say, well, if there's other ways that I could get this, where I can get exactly the same information I'm looking for, but it's not going to, it's easier than this, just let me know what it is. And I think, like Walter said, that the clerks who are really interested in doing their jobs correctly will honor that on a genuine basis. The ones who aren't, they look at that and they say, I see where this is going. If I play around and I play coy and I play hide the ball with this requester, and some superior court judge down the road is looking at this request and the earnestness of the request and the sincerity of the request, and I just give them the back of my hand, I don't think that's going to go well for me or my municipality or my school board. So maybe I better at least pretend to be a responsive clerk and responsible and give the guy what he wants. So generally, I see either way, it really works out. So, you know, it's a matter of making the request and making it and reminding them of the legislature's purpose and what their position is, and hopefully they'll do the right thing.
Okay. Mr. Shore, I know you've been waiting for some time with a question.
Let me say this first. As a former clerk, when you approach a clerk, and the clerk should look at it the same way, you have to become partners. Now, you may not know what you want, but the statute says you're entitled to review documents. I had a request from the Bergen Record one time, and they didn't know exactly what they wanted. The request happened to be in the building department. I set up an appointment with the reporter, the head of the building department, and they went through the files, marking the documents that they wanted, and then they came in with their own photocopy machine and copied the documents, permitted by law. I did have a clerk stand with them to observe that no document was misplaced, marked wrong, or whatever have you. But become their partner. You will get more. I think the biggest example I can give right now was I got a request from John Paff. And I looked at it. And I said, The first thing I did is I picked up a telephone, I called John, we discussed what he was looking for, why he was looking for it. I fulfilled his request, and I got a follow-up letter. The follow-up letter was some suggestions to me, and that was to change my resolution, if you remember, John, going into closed. You felt it was too broad. I looked at it. John had submitted to me a suggestion. I took it to my municipal attorney. And that was adopted by me because the council does not have to adopt a resolution. And to my knowledge, to this day, it is still used in the municipality. Yes, become a partner. You'll get a lot more.
I agree with you on that 100%. I just wanted to add that not every municipal clerk is as forthcoming. Some municipal clerks are. Well, some are afraid of their jobs, and you know they're being told to put the brakes on things, and they have to. They're decent people, but they're being cornered by others. They're being bullied by others in the municipal administration and the elected officials as to not provide certain records. Yeah. And other ones are just part of the machine politics that goes on in the town, and they just are, I think, predisposed to not give you records. That's just their modus operandi.
Yeah, I mean, one of the troubles with OPRA, it's not really a trouble, but in terms of municipalities, OPRA specifically designates the municipal clerk as the records custodian. So even if the problem lies with someone else, the ultimate responsibility is with the municipal clerk to fulfill records. So when I file a lawsuit against a municipality, against a township, I'm always naming the clerk, even if it's not necessarily their fault. Maybe they're getting stonewalled by someone else, but unfortunately the law, unlike school boards and state agencies who can designate their own custodian, municipal clerks are unique in that the law specifically gives them the responsibility as the records custodian. Okay, I saw a question over here.
I live in Bloomfield, and we've been filing quite a few OPRA requests, and I'm finding what I'm getting back is sort of insufficient search, but not by the clerk, by, like we're OPRAing the town council's emails with certain terms. And I'm trying to triangulate, some people are filing, we're filing different OPRA requests, and I'll find that the response that I get is not necessarily complete, because I find something that should have been given to me in one OPRA request, I find it in somebody else's OPRA request.
If I think that the problem lies somewhere other than the clerk, and I think that we have a particular person who's not giving records, either because they're doing so intentionally or they're making a negligent search, which, by the way, it doesn't, from a disclosure perspective, it doesn't matter whether the search is negligent or not. If the records exist, they have to be disclosed. Negligence is not an issue. The care they exercise is not an issue in terms of disclosure. But be that as it may, if I think there's a specific problem, I will name the individual who is the problem. So for example, let's say I'm suing a town for police records. Depending on the circumstances, I'll name the town, I'll name the municipal clerk, the civil clerk, and then I'll also name maybe whoever's in charge of records in the police department, because they're the person who may actually know where the records are. If there's a council member who's not giving emails, well, I will name the person in the lawsuit specifically, so that means they get served with a lawsuit and they have to appear by counsel and the whole thing. Now, it's a little different with the Government Records Council. Government Records Council, you're always naming just the clerk or the public body, and you can try to name other people, but it's up to the Government Records Council as to whether they'll include those folks. I'll tell you that if you think an individual is being a problem, give the Government Records Council that evidence, make it clear to them, and then if they think there's a problem, they will begin to include that person, that council member, in the litigation. And so they'll say, well, look, we're not going to direct our order for disclosure to the clerk because the clerk did his or her job. We'll direct our order of disclosure to a specific employee or a specific council member who they think is being a problem.
Yeah, I'll get that with the clerk is very diligent and the police department's not, and he asks for police records. And I've seen the clerks go so far as to get the police records person to sign off on their request and then come back to me and say, look, I've done everything I'm supposed to do. I've given this to the police department, and they haven't given it back to me, and I've tried twice. So then they're basically saying, go do what you got to do, but keep me out of the line of fire. Okay, so that happens.
Right. Sure. No, Mike, did you have something? Yeah, Mike was first.
If you're looking for records and you're not sure what you're looking for, a good place to start is the Division of Archives Records Management, because they keep a very extensive list of what records government entities are required to keep, how long they're required to keep them, and how they are to dispose of them. So that's a really good place to start if you really are on a hunt and you're not, well, what records should I ask, and you're not getting any help. That's another resource that you can make use of.
Well, where can you find those records retention schedules?
It's actually right on your website.
Whose website?
The Division of Archive Records Management, DARM.
If you put NJ space DARM in a search engine, you'll get what you're looking for.
Okay. Yes, ma'am.
Hi. Question. If you know, I'm involved in a lawsuit in my township, and I know that there were private meetings between the township officials, including the attorney and the clerk and the mayor, and this private organization. Should any minutes be available?
Well, that's a nice segue into the Open Public Meetings Act.
Certainly is. I think that, well, it depends. It depends. I mean,
let's start with the rule. What's the rule with respect to public meetings? What is a public agency supposed to do?
Well, a public agency is a body that can spend money, essentially, duly constituted to spend money or to affect people's rights, just roughly. But when you have is this a committee, or this is a subset of the whole body?
This would be the attorney,
right?
one member of the committee, and the township clerk, township
I think that they can meet. I don't think they have to keep minutes. If it's a body, they have to keep minutes. If it's not a public body, they don't have to keep minutes. So you can't, now if they do keep minutes, then you can compel, I mean, if they gratuitously or volunteer to keep minutes that they're not required to keep, you can OPRA those minutes. But if they choose not to, I don't think you have any remedy.
How many members of a governing body have to meet before the Open Public Meetings Act requirement of minutes kicks in?
Depending on who you ask, the term that the legislature uses, I like this argument. Nobody else seems to be so like.
Because it hasn't been successful.
It hasn't been successful, but everybody equates the term effective majority with quorum. So we have a 7-member body. An effective majority or a quorum of that body is 4.
An effective majority is the language that appears in the statute?
Effective majority is what appears in the statute. And a judge in, I believe it was Burlington, I have to think which judge it was, Judge Sweeney, I think it was, said that in kind of like just an aside in his opinion, well, this was a 9-member board. He said, well, an effective majority of a 9-member board is 3. How so, Judge? Well, a majority is a quorum, and that's 5. So if 5 members were to meet, that's a quorum, and they can transact business. So 3 of those members could lock the vote to get something through if only 5 of them showed up. And that has some appeal to it. I mean, so if, let's say that your 9-member school board were to know in advance that 4 of its members are going to be on vacation or out of town during an upcoming meeting, and then 3 of them say, hey, you know something, we're going to be able to transact some business here at this upcoming meeting, and the 3 of us sitting right here in this room can pretty much call the shots. Let's meet and talk about what we're going to do, because we know this and we're going to use, but by the way, there's only 3 of us, we're not a quorum, so we don't have to keep any minutes or invite the public to this meeting. I have a problem with that. I mean, if they know, at least under that set of facts, they know that they are going to be the effective majority at the upcoming meeting where only 5 of them are going to be in attendance. Well, I think that that's about what the legislature meant. I mean, you have to look at the Open Public Meetings Act in the context of what it is trying to accomplish. The overall legislative purpose, as it says right in the preamble, that the public being able to access meetings is of vital public importance. Not just it's a good thing, it's of vital public importance, and democracy depends upon an informed citizenry. So we have all this lofty language. Then in 21 of the Open Public Meetings Act, it says, and anytime a court is called upon to interpret this statute, the court shall interpret the statute liberally in order to accomplish the legislative vitality of democracy, things that we said before. So against that backdrop, I believe that there is a problem if 5 guys on a board of education, knowing that 4 of them are going to be, the other 4 are going to be absent at an upcoming meeting, decide to hide behind the fact that they're not a majority and have a meeting without inviting the public to it when they know darn well that they're going to be able to call the shots at that meeting. That flies in the face and is completely opposed to what the legislature said. But the problem with all of this is that there is no, like I said before, there is no fee-shifting provision in OPMA. So there's not many lawsuits filed. Not many people go out and file a lawsuit against the government agency because they didn't keep their minutes right, or they met without a quorum, or they did something they weren't supposed to do. So it's easy for these people to get away with this. And the lack of case law doesn't mean you have to sue everybody. The lack of case law doesn't give the municipal attorneys and the public agency attorneys sufficient bright lines and guideposts to be able to guide their clients. And some of the attorneys recognize that they're not really being hired to give information on how to open up their body to the public. They're being hired essentially to be able to keep their body outside of the radar, but as close as possible to suppressing information as much as they can without being called upon it or being looked upon as being, well, you're out of your mind. So the problem is we don't have enough litigation that have defined even some of the most basic questions dealing with the Open Public Meetings Act, like, for instance, whether an effective majority means quorum. I mean, the legislature could have simply said quorum. They didn't. They said effective majority. So what does that mean? And we haven't had the litigation because there is no attorney fee shifting provision, and most residents, even the people in this room, were probably the most engaged people in this process, are not going to hire an attorney and spend $5,000 of their own money in order to settle a question regarding whether the town is keeping its minutes correctly, because it doesn't make financial sense to do that. So I think one of the most important aspects, and I know we're getting off topic, is to get legislation that will make it so that if at least some threshold is met against an agency who errs or violates the Open Public Meetings Act, that the successful claimant gets paid their attorney's fees. That is going to make it fair, where now, you know, you can actually win and you can actually break even if you have a good case. That'll cause attorneys to say, I'll be willing to take that case on the prospect that I might win and get attorney's fees out of the town. It's not about enriching the attorneys, it's about making it a fair playing field so that you can actually get the litigation that's needed. The problem is it costs too much money. The transactional cost of filing a lawsuit are high, and attorneys are, in my view, way too expensive. It shouldn't cost this much money to access the legal system, but it does. That's the reality. And I don't know how to change that, but I do know that the only thing we can do is to get it where the citizen is not up against it, where they got to pay thousands of dollars, because since 1975 this law has been in force, there haven't been enough cases. Nobody files, nobody enforces it. And that's kind of like venting a little bit, but that's essentially the problem.
Right, and you know, getting back to the specific question, you know, the law as I currently, you know, envision it is if a public agency meets and it's less than a quorum, then there's nothing wrong with that. I understand that sometimes critical business gets discussed in these committees or these subcommittees, and then they work on stuff and they email each other, and then, you know, resolutions and ordinances sort of magically appear at meetings and everything's been already thought out. But it is a little bit of a loophole, and we'll talk about ways that might be changed later today.
I just want to make sure that people understand what the legislature said, okay? The legislature finds and declares that the right of the public to be present at all meetings of public bodies, and this is the good part, and to witness in full detail all phases of the deliberation, policy formulation, and decision-making of public bodies is vital to the enhancement and proper functioning of the democratic process. That secrecy in public affairs undermines the faith of the public in government and the public's effectiveness in fulfilling its role in a democratic society. Now, I have a problem with the way the conventional wisdom that it's okay for a Board of Education to have a 3-member XYZ committee that hashes out all this detailed policy formation and deliberations behind closed doors, trades all the horses, figures out all these things, and then what the public is treated to is a sterile wooden vote, just an affirmation, a ratification of predetermined choices. I see it happen all the time. That's not democracy, that's crap, okay? And this is what we have to do, is to get people to understand that when the legislature wrote this in 1975, what they meant was that if I was an engaged citizen, or if you're an engaged citizen and I'm interested in this process in this town, I get to see those nuts and bolts. I get to see those horses getting traded. I get to see something more than just all in favor say aye, all opposed no. And what the overall problem is that sometimes people, and what always galls me is when I go to a public meeting and the mayor says, it's just so unfortunate that so many people are just home watching TV instead of coming to our meeting. Well, Madam Mayor, the reason why they're not coming to your meeting is there's nothing to see here. You've already made the decisions behind closed doors. What they get to see is the Boy Scouts get a plaque and everybody applauds, and then they get to see you go into closed sessions for an indeterminate period of time, so they don't know whether they're supposed to wait around or go get a cup of coffee, or they might miss something because you don't tell them. They then get to see a whole bunch of resolutions on a consent agenda get done by one thing, and not one person says no or nay or asks a meaningful question. And when the public stands up at the end and finally has to say what it has to say, they're usually, maybe sometimes berated and ridiculed by the chair of the meeting, and sometimes they're simply ignored and told, we don't have to answer your questions, next. So, Madam Mayor, maybe the reason why people don't show up at your meetings is because your meetings stink. Maybe it isn't because people are not, I think the people were engaged. I think people want to know what's going on. If you made your meetings more meaningful, maybe you would get more public participation that you allegedly want. But there's something wrong, in my view, with a statute that says this, and to me, this speaks so clearly. Policy formulations and deliberations, the right of the public to attend, the right of the public to witness, this is core. And what the reality is, 35 years later, compared to what we're supposed to get, they do not correspond. And we have to do something. We have a good Records Act. I think the Records Act works reasonably well, and you can get good results out of the Records Act. And the common law right of access, we need to talk to about sometime today. But this Meetings Act is so underutilized. It's essentially, it's been devoid, it's through the use of committees and the use of all these tools they use to get around them, it's been essentially made into an ineffective dead letter. And this has to be revived, and the original legislative meaning behind this act has to be reinserted into the public policy. And I think that we're going to see a lot of benefits in the type of government we get if this occurs. If it takes legislation, so be it. If it takes court cases, but we have to get there. And the only way that I can see to get there is to get the legislature, if the legislature did nothing but changed it so that there's attorney fee provision to enforce the existing act, that would be a great step forward. And that's my position on it.
Chris, you want to take that question? No, that gentleman. He was first.
I'd like to suggest that short of a lawsuit, you could make a friend, like you make a friend with a clerk. For example, if you had a subcommittee chairman of a Board of Education who could invite you to attend the October or November meeting declaring you an expert in this field, make arrangements with me at an intermission to receive that invitation from me, please.
If I receive an invitation, one thing that I've always, sorry?
You have it. I'm a subcommittee chairman and I invite you hereby.
Okay, what town is that?
Bedminster. Board of
Okay,
Education.
I know where it is. Okay, we'll get in touch. The other thing is too, is that if you are a member of something, and they're playing this, a lot of times what happens is you have at least in my experience, is you have the important committees. There's 6 members of the Democratic Party and 1 member of the Republican Party. It could be the other way around. It doesn't really matter. I don't think I'm not pro either one of these parties, but we're anti one for that matter. But what they do is they will arrange it where they have their 3-member committees that do all the important stuff, and they usually exclude the minority party member from any of the committees that actually matter. And I always suggest that the political minority member ask for when that meeting is going to happen of the police committee. The 3-member Democrats, the 3-member the majorities that are going to be on that police committee, when is their meeting? Because I'd like to go. And if I go, it'll be 4. And you've got to notice it in sunshine and open it up to the public. I don't see any reason why they don't do that. I would think that, are they going to actually exclude these committee members from actually attending a meeting? And if they do want to exclude the members from attending the meeting for the precise purpose, for the apparent purpose of avoiding public accountability under the OPMA, well, then let them do that. Let them say, I'm sorry, we're not telling you when the meetings are, and if you do happen to find out, you can't come because that would require, that would sound bad for us to say that would require us to open the meetings to the public. So sometimes you don't always win, but if you want to, what I like to do is strip off the veneer of all this and make them at least, if they're going to deny public access to things that the public ought to have access to, make them affirmatively stand up and say, I'm sorry, I would consider this meeting being open to the public to be too much access for the public. I don't agree with what the legislature said in 1975. Make them say, I think that really the legislature was wrong and the public really needs just to take our word for it because we're the experts here. Let them come out and say that and see how that resonates with the voters. So the member, the odd member, the one who's in the political minority, can do an awful lot of damage. I say damage, and then maybe I shouldn't say it, can cause a lot of mischief, can bring a lot of open government to a body by being persistent and deciding to attend all the committee meetings as a member and making them open up to the public. Then what they'll do is they'll tell one of the 3 to absent himself from the meetings. Just develop a pattern of that and call them out for what they are. Another thing, first off, The only people that talk to me that serve on municipal bodies are in the political minority. If they're on the political majority, they got no business talking to me. They got no reason to. The ones who call me are the ones that say, I can't believe I got elected, and now they won't tell me anything, okay? To those people, if there's any in the room, and to anybody who knows them, I would suggest a couple things. Go to the executive session meeting minutes, go to the executive session meetings, which you're certainly allowed to go as a member of the public body, and take notes. Because the minutes, if you look at your meeting minutes and see if they're reasonably comprehensible, and take comprehensive notes of the meeting that you attended, naming names, all the details, take pages and pages of notes of what occurred, what everybody said at this public meeting, and then put it in an envelope and give it to the clerk and file it as a government record. What a lot of the towns do now is they just keep lousy minutes. The minutes themselves, there's nothing to redact. They freely give me full, unredacted versions of their minutes, but the minutes are so brief and so terse that there's no meaningful information kept in them. I've seen them to a point where they say, we started at 7:42 p.m. and we ended at 9:17 p.m. and we discussed certain negotiations, period. That's not, so if that's what your body is doing, and if you happen to be fortunate enough to be on your public body as a minority member and getting short shrift, do what I just said and let everybody know. And now what you're doing is essentially taking effectively the de facto minutes of the meeting. You're doing their job for them and keeping a permanent record. And if you're a public official doing this in the course of your official business, and you give it to the municipal clerk in the course of his or her official business, and she files that in her office, that is a government record subject to OPRA.
Okay. Now, we're getting close to the end of this particular panel. I know there's more questions. I'm sorry, I'm not going to get to you. If you have questions you want to discuss with us, you know, John and I will be around all day. Other board members will be around all day. So, you know, sort of corner us and ask us the questions. I'm sort of cutting things off because I want John to talk a little bit about the common law right of access, which is very important, and it doesn't really get a lot of play. Both John and I have had cases where we've lost our case under OPRA, but then we've won our case under the common law right of access. John, would you mind talking a little bit about the common law right of access?
I can think of nothing I would rather do more. The common law right of access is very important, and I'm going to, if I can figure out how to get this thing to do what it's supposed to do. Well, anyway, it says, nothing in common law right of access. Before there was OPRA, before there was the right to know law in 1963 and any other statute, people have always had a right to look at records because the common law, as it was brought over from colonial times and is now the basis of our current law, is still law in the state of New Jersey. New Jersey is a common law state. The common law is still recognized unless it is abrogated specifically by some statute or some court decision. So the legislature, when it passed OPRA, it said, nothing in this act is intended to or shall be construed to limit a citizen's right to access under the common law right of access. Then they put another sentence in there that kind of tickles me. It says, including criminal investigatory records held by a law enforcement agency. So they couldn't make it just general. They had to say, and we really mean even the cop stuff. That's subject to common law right of access. Okay, and I go, okay, so that's what they said. But what it basically is, and they put all these 3-pronged tests and 5-pronged tests that you have to analyze. Essentially, though, basically what it is, it's a balancing of the government's right to or need to suppress the information against the citizen's need or the public's need for disclosure. The court just has to do a sort of a balancing. Now, there are factors, the Loigman factors, like what's this going to do and the court has to go through this. But bottom line is my interest in knowing greater than their interest in suppression? And because what happens is OPRA is like an on-off thing. It's like there is an exception, you don't get it. It falls within this exception, therefore records request denied. It's very cut and dried. But the common law right of access is more nuanced. They have to say, I mean, I can say, yes, sure, there is a statute that says specifically that I'm not allowed to get this record that I'm asking for, but I assert an interest that I think that under my particular case, I believe that my personal interest or a wholesome public interest is better served by disclosure than by suppression. And we want the court to go through this, what they call the exquisite balancing test. So the judge actually has to balance out. Now, the GRC will not do this. They don't have jurisdiction over the common law right of access. but the Superior Court does, and they will give records. Like, I hope we will win and prevail in a case we have in Egg Harbor Township in Atlantic County, where an officer, an off-duty, actually just a motorist, was in a private vehicle at 2 o'clock in the morning and asleep at the wheel while several rotations of the traffic light occurred in Northfield, New Jersey. At 2 o'clock in the morning, everybody do the math. What happens is the police arrive and alerted to this vehicle acting strangely out here, and they see the driver slumped behind the wheel, and they say there's alcohol in breath, AOB. There's, you know, it looks like we got a DUI coming up. Then all of a sudden we realize that it's Officer so-and-so from the next town over, and then everything changes. So now there's a whole police investigation, and there's this and there's that. But what the bottom line is that I think everybody knows that if it was anybody, if it was a non-law enforcement related person behind the wheel of their motor vehicle at 2 o'clock in the morning with alcohol in their breath, there would be a certain predictable result of how the police would respond to that. And this didn't happen. Here, the officer, a lieutenant was called, or a sergeant was called, and the sergeant drove the officer home. And then the official story became that the officer was moonlighting, and he was just working so hard, he was just so darn tired that he fell asleep behind the wheel of the car. But then that begs the question, well, why didn't they just wake him up and have him drive home himself? What did he need a ride? Was he that tired? I mean, the whole thing doesn't make any sense. It's all crazy. But under OPRA, we probably don't have a right because the police heavily lobbied, and every other, I mean, this is a heavily negotiated thing, OPRA. You know, everybody's got their little thing that they all went to the legislature and they said, well, we'll only give this up. And so it was like kind of like a satisfying everybody. It's something that typically comes out of a political process. But the common law right of access has nothing to do with that. So even if they're able to identify an exception, you can still say under the common law right of access. And I will tell you almost 100% of the time, I put on my request, I request these records under the Open Public Records Act, OPRA, parenthetically, and the common law right of access. I want this, I want this, I want this, I want this. Then they come back and they say, you can't have this, this, and this, but they never even articulate a basis under the common law right. They just ignore that whole part that says common law right of access. They don't even really deal with it. So people need to start to understand that this is a really, especially the stuff that they, like police records and things, the common law right of access is one of your best friends. One of the problems is that it is unclear at this point whether the attorney fee shifting provision applies if you win under the common law right of access but not under OPRA. We don't know the answer to that. It's before the appellate division. The appellate division has been dealing with Paff versus Garwood for some time now where that question is precisely asked. According to the Union County Superior Court, yes, but Garwood appealed. And they feel that I believe they want to discourage people from having, well, for whatever the reason, I don't want to attach motivations, but the question, if attorney's fees are awarded in common law right of access cases, that'll be a tremendous help for people who are trying to get records in the state of New Jersey. So it's essentially a balancing test. And don't forget to put it in your requests.
Okay. It's 11:15. Thank you, John. A lot of good information. We're going to take like a 30-second break if folks want to get coffee, and then we'll move to Tom McLeod from the ACLU.